from 2010 to 2011, the Justice Department has objected to only 29 of nearly 20,000 proposed voting changes. Now, so at one level, you can say, actually, this isn't imposing some huge burden. This isn't an overreach. But I think people who think the law should no longer be in effect say, look, it's the problem is solved, right?
Right.
Why do you want to keep insulting the sovereign dignity of the great state of Alabama if it turns out that what is that, 99%, more than 99% are getting clear?
I would say that the number, Chris, has always been less than 1% of the number of objections. The number of proposed changes are objected to. So the number has always been small, but the actual each objection protects many voters. And so, for example, in the state of Texas, for example, we recently saw the Department of Justice rejected Texas's photo ID measure. They later litigated that case and lost again before a 3-judge federal court. Yeah. In the state of Texas, we saw there were 600,000 people who didn't have the type of ID that Texas was requiring, 170,000 of whom were people of color. So each objection protects many voters, and the number of objections has always been small.
I want to bring in Horace Cooper, adjunct fellow with the National Center for Public Policy Research, co-chairman of the Project 21 National Advisory Board, a group of blacks and conservatives that filed an amicus brief to strike down Section 5 of the Voting Rights Act. And Horace, what I think is interesting here is, the Voting Rights Act is in an American political landscape that is remarkably polarized, is incredibly unanimously or near unanimously supported. I mean, the margins, it's been reauthorized 4 times, huge margins. In 2006. I don't think there was a single dissenting vote in the Senate. It was 98-0. And I want to play for you just a little bit of sound from 3 Republican presidents who signed reauthorization of the law. Take a listen.
There must be no question whatsoever about the right of each eligible American, each eligible citizen to participate in our elective process. The extension of this act will help to ensure that right.
The right to vote is the crown jewel of American liberties, and we will not see its luster diminished.
Today, we renew a bill that helped bring a community on the margins into the life of American democracy. My administration will vigorously enforce the provisions of this law, and we will defend it in court.
And my question to you, Horace, is given this bipartisan support, given the extensive congressional record, given all this, shouldn't there be a lot of deference afforded to the executive and to Congress that has made these determinations? Why should we be overturning something that has such broad support in the American public?
Well, naturally, of course, the Supreme Court will give the great degree of deference to the Congress and the President, as they should. That is the natural process for all of these. But the problem is that much of the discussion that's occurred this morning is failing to appreciate that there are certain legal principles that are at stake. The Supreme Court is not going to be making a diagnosis of whether or not the South has made progress in terms of racial lines or not. They're going to be addressing specific factual issues and the legal arguments that are associated with those. Much of that has been missed in this morning's conversation.
But the factual issues, you're right, it is. But they are going to be addressing factual issues. Let me read you from the last time the court talked about this issue with the Northwest Austin Municipal District. I can never say NANAMO, whatever the hell it said. This is Chief Justice Roberts saying, more than 40 years ago, this court concluded that exceptional conditions prevailing in certain parts of the country justified extraordinary legislation otherwise unfamiliar to our federal system, right, which is this idea of covered jurisdiction. Some places get this a certain amount of federal interference, other places don't. In part due to the success of that legislation, we are now a very different nation. Whether conditions continue to justify such legislation is a difficult constitutional question we do not answer today. The test that the Chief Justice himself enunciates in that section of his previous opinion is about whether the conditions continue to justify such legislation. The conditions are a matter of fact, and so the court is going to be making a factual determination about those conditions, won't it?
I'm sorry, you're looking at the rhetoric portion of the ruling and assuming that that's going to be the basis for the actual determination. And the fact of the matter is that the actual serious constitutional challenge of separating some states out and treating them one way challenges the notion of state sovereignty. And equal sovereignty doctrine is a serious issue that's going to have to be addressed.
Yeah, so this is the argument. This is in oral arguments. Justice Kennedy enunciated this quite famously, basically saying you are implying the sovereign dignity of Georgia is less than the sovereign dignity of Ohio.
Right, I think Justice Kennedy is seriously looking at the question of whether or not he thinks that what Congress did in 2006 was within that circle that I sort of talked about a minute ago of where Congress is allowed to act to stop unconstitutional conduct. He's looking at that question, but I think that the evidence that Ryan was talking about, the pastor was talking about, answers the question. We're so in the circle. Like, I don't know what the debate is about.
Right. And in 2006, this was before the Congress, and they found that states that are subject to Section 5 made up about 25% of the U.S. population, but they accounted for 52% of violations of other parts of the Voting Rights Act. You look at the 2012 election, states covered in full by Section 5, 2/3 of them passed new voting restrictions, compared to 1/3 of the non-covered jurisdictions. So it's not like there isn't a problem in Ohio or Michigan, but the problem is worse still in places like Alabama and Mississippi.
Horace, I want to talk to you. I want to litigate a little more this differentiation question because it's sort of the core of much of the case right after we take this break.